First of all, a little bit of news out of the case. Do you remember this guy from a few weeks ago? Remember him? He is an attorney from Mountain Home, Idaho, just down the road from here, about an hour away, who filed that motion to intervene on 11:45 on the Friday before the case. He said that he represented Chad Daybell, that he was worried that the case wasn't ready for trial. There was typos galore. He misrepresented who he was. He had the wrong case number on there. It was quite a thing. And then he asked for a hearing in front of Judge Boyce. I don't think I've ever seen anything like it. I know attorneys who have practiced law for a long time, and they say they've never seen anything like it, where the judge basically said, you screwed up, you are wasting our time, and I'm going to sanction you. This attorney was Terry Ratliff. We covered it. You can go back and watch it. Well, the judge has issued an order imposing those sanctions. This came down the 20th, yesterday afternoon, around 3:30. I want to read it with you. Can you see it here? On March 29th, attorney Terry S. Ratliff filed a motion purporting to intervene in the above-captioned case and moving the court for a continuance of the scheduled jury trial. Pause right there. What does it mean? He filed this motion saying that the trial needed to stop. It needed to be continued or rescheduled, delayed, postponed, because he wanted to intervene in the case. The court ordered him to show cause, and a hearing took place on April 18th. At the hearing, the court determined that Rule 11, Idaho, Rule 11, applied to the filed motion and had been violated, requiring the imposition of a sanction. The court determined that the appropriate sanction was the payment of attorney fees incurred by the parties in dealing with the motion and requested that the attorneys submit their fees for review. The court has received counsel's memorandum of costs. Therefore, the court makes the additional findings of fact and conclusion of law. And then here's a little background. Terry S. Ratliff is an attorney licensed by the Idaho State Bar. On March 29th, 2024, at 11:42 p.m., Friday night, 11:42, right before the trial's jury selection is supposed to begin on Monday, Mr. Ratliff filed an error-filled and frivolous pleading in the above-captioned case. Mr. Ratliff held himself out as attorney for defendant in the caption of the pleading, and in his signature on both the pleading and the pleading's certificate of service, that's what he said. Mr. Ratliff is not and has never been the attorney for the defendant in this case. This pleading falsely and materially misrepresented the fact. The pleading filed by Mr. Ratliff required a response from the court and counsel for both parties on the eve of a major trial. The pleading caused the parties to unnecessarily divert resources and time in responding and unnecessarily increased the cost of the litigation in this case. At the April 18th hearing, Mr. Ratliff was given a reasonable opportunity to respond. He offered no plausible explanation for the misrepresentation that he was the defendant's attorney. He told the judge he was stressed, he was worried, it was a mistake, it was a Scribner's error. He did it 3 times. The court determines that the pleading violated Idaho Code 11 and that the rule applies in this criminal case. And then he goes on to say, counsel for the defendant has submitted documentation that he spent 3 hours addressing the frivolous pleading, including attending the hearing on March 18th. John Pryor's normal hourly rate is $350 an hour. The court finds that both the time claimed and hourly rate are reasonable, resulting in attorney fees of $1,050. The state of Idaho spent 2.75 hours addressing the pleading. The fees for the state of Idaho are $65 an hour, total of $178.75. Let's just pause right there and divert for a minute. Look at the rate disparity between those. If you practice private counsel, private attorney in Idaho versus public servant versus a prosecutor. Prosecutors don't make much here. Public defenders don't make much here. The money's where judges honestly don't make much here. The money is where when you're in private practice. Pryor can set his rate. It's $350 an hour. The state charges $65 an hour. So the state, out of all this, they put in about the same amount of time, $178. Pryor gets over $1,000. The court finds the state's request is reasonable in both hour and time. Additionally, we're going to scroll down. The court has considered whether its own time spent on the pleading should be added as well, and has determined that the sanction of time from both parties suffices as a reasonable and adequate sanction. Therefore, the court sanctions Mr. Ratliff a sum of $1,228.75. So he added the two together. So Ratliff has to pay $1,000 to Pryor, $178 to the state, and then has sanctions of $1,200.